Hello, my name is Darrell Miller. I'm the Melvin G. Sham Professor of Law at Duke Law School, and I'm co-director of the Center for Firearms Law here at Duke Law School. Welcome to a panel on Corpus Linguistics, Constitutional Interpretation, and the Right to Keep and Bear Arms. This panel is sponsored by Duke Center for Firearms Law and co-sponsored by Duke's Federal Society and American Constitution Society. We've rescheduled this event from March in light of the coronavirus and taken it online, and I'm extremely appreciative to our two distinguished guests who are willing to participate via Zoom today. Our first guest is Neal Goldfarb. He's the Dean's Visiting Scholar at Georgetown Law School and a litigator with almost 40 years of experience as a blogger on Law and Linguistics, a blog dedicated to linguistics and legal interpretation. Our second guest is our own Stephen Sachs, professor of law at Duke Law School and an expert on legal interpretation, civil procedure, constitutional law, and legal theory. Constitutional interpretation has increasingly turned to history and a close reading of the text to decipher meaning. Scholars have begun mining newly available databases called a corpus that contains thousands of works and millions of words from the founding era to shed light on questions about the typical use of words at the time the Constitution was drafted and ratified, including the Second Amendment rights to keep and bear arms. We're here to discuss the role of these new big data techniques in constitutional interpretation. But first, I want to frame out the nature of the debate, both with respect to the constitutional interpretation and the Second Amendment in particular. Now, originalism is a term that's frequently used, but what is it? Well, the genealogy of originalism is frequently tied to a speech that Attorney General Ed Meese made to the American Bar Association in 1985, advocating for a constitutional interpretation of original intention. That is, an examination of the intentions of the framers of the Constitution to see what they intended the Constitution to mean. The idea of originalists was to attempt to take the discretion out of the hands of judges and make the law more objective. Original intentions as a theory of interpretation suffered some major theoretical problems, however. First, the intentions of one person may be difficult to discern and unstable over time, and multiplied over the entire Constitutional Convention of 55 delegates, it becomes even more difficult. Second, it's not the intentions of James Madison or the convention goers that makes the Constitution law, it's we the people of the United States. Now, eventually originalism moved away from a search for intentions and then began as a search for meaning. That is, the constitutional law was not the intentions of the enactors of the Constitutional Convention, but it is commonly understood as what did the meaning of the words mean at the time they were ratified in 1791. This became known as original public meaning originalism. Now, originalism as a public meaning type of originalism was applied in the 2008 decision, District of Columbia versus Heller. This was the first Supreme Court case in 200 years to hold that the right to keep and bear arms was an individual right for personal purposes of arms, unassociated with an organized militia. Now, the text of that amendment, the Second Amendment, is a short 27 words and states, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Justice Scalia wrote for the majority and held that the original public meaning of those terms would have been the right of the people to keep and bear arms was the same today as it was in 1791, a right to possess and carry arms for personal purposes. Justice Stevens wrote a dissent and also used public meaning originalist methods. He saw evidence instead that the founding generation in 1791 would have understood the terms keep and bear arms to have a military meaning associated with a militia, and that the terms keep and bear arms had not changed since that time. That brings us to our panelists, and I'll begin with Neal. So when Heller was decided, the parties were working with a limited set of documents, perhaps 115 at the most. But we now have access to thousands of records and millions of words in a corpus. Can you tell us a little about what a corpus is and how is it relevant to this public meaning originalism in general, and to the debate over the Second Amendment in particular?
Sure. And first of all, let me thank you very much for having me here. It's a pleasure and honor to be, especially on a panel with Steve, and it's such a prominent moderator also. Corpus Linguistics is the name of the field of linguistics, and the database of text is called a corpus, and the plural of that is corpora. The corpora that we use for this purpose, for this kind of analysis, is been put together by Brigham Young Law School, which has gotten very big into corpus linguistics, and it consists of about, I think it's about a third of all of the printed documents that have survived and available from the founding era. So it's a very large group of texts, and with a corpus, the interface, it's available for free on the web. It's set up in a way that enables you to do linguistically oriented searches. So one of the things it can do, for instance, is you can run through hundreds of lines using bare arms or arms were born or they were bearing arms, any combination like that. And it's sort of a spreadsheet where you can just run down with bare arms would be in the middle column and then the context is on either side. So it's very simple to run down quickly and categorize things as you go, much more, it would be impossible to do just with the actual documents. So using that as a resource, what I did was, and other people have done this also, including Dennis Barron, who's one of the amici in Heller, in the linguist amici, is to look at the corpus data using the original public meaning perspective that was used in Heller to see how would those terms have likely been understood by people at the end of the 18th century. And the most important piece of the results is that bear arms was not usually understood to mean carry weapons, which is what not usually used. We infer from that it wasn't understood, but all we have is the evidence of usage, but it certainly was not usually used to mean carry weapons. It was used in a figurative sense to refer to, fighting in the military, being in a war, or something like that. And I think what I argue is that it actually was probably understood to mean be in the militia, because that was, when you actually look at some of the old militia statutes, they talk about bearing arms and being in the militia as essentially synonymous. So my take on it, and this has, none of this, what I found has been disputed by any of the gun rights advocates. But what I found is that the ordinary use of bear arms was in military sense, not in personal self-defense sense, which is contrary to Heller. There were also some, I looked at other issues, and there are a few things that I think are some ambiguity, but that doesn't really help to support Heller, because Heller said we don't look at the preamble, well-regulated militia being necessary to the security of a free state. Heller said we don't look at that unless the main clause is ambiguous, and Heller found it was not ambiguous. Well, I think, at worst, at a minimum, it was ambiguous if it's not clearly military reading. And the ambiguity means you look at the preamble, which I think means that Heller is wrong. Now, that doesn't resolve how the Second Amendment would be interpreted, but it does suggest to me that you need to go back to square one.
Great. Thanks, Neal. Steve, you're the leading advocate, or at least the scholar, on an alternative to what we might think of as original public meaning originalism, something that you and Will Bode at Chicago have termed sort of original law originalism. Maybe you can help us sort of understand the terms of the debate, the distinction between original public meaning originalism and what you describe as original law originalism, and how does that play out with respect to this question about how we are to interpret the words keep and bear arms?
Sure thing. So first of all, thank you to Darrell for having me, and to Neal and for our sponsors for organizing this. The approach of original public meaning has generally been focused very much on the meaning of the words and the meaning of the words in the text to the ordinary member of the public. The difficulty in that is that the reason we care about these words in the first place is not just because that's how the ordinary person might have understood them, but because they were legally adopted. We care about the Second Amendment, presumably, because it was adopted and has never been repealed. And so whatever right to keep and bear arms it conferred in 1791, unless something else legally relevant happened, is the same right to keep and bear arms that we enjoy today. And so the original law approach really tries to ask what law was made by this instrument having been adopted at a particular time in a particular way. Now, often the meaning of the words to an ordinary member of the public is going to be highly relevant to that. I mean, the two inquiries often line up in precisely the same way, but sometimes they come apart. So for instance, if you wanted to know about the freedom of speech or the freedom of the press, it would be one important piece of information to get out some, founding era dictionaries or dictionary equivalents and try and figure out, the meanings of the word freedom and of and speech and press to ordinary people. But it would also be really relevant to know whether there was a legal object at the time, a common law or other freedom of speech or freedom of the press that might have been entrenched against congressional abrogation. Now, part of this is captured linguistically with the idea of terms of art, whether the freedom of speech is a thing. But the point is that the can carry an awful lot of meaning. It might be all sorts of common law exceptions and incrustations and other things were going on. And so the approach of many originalists to focus very closely on the text might be a little too close of a focus. It might lose some really important legal context that one would also need to know in order to answer the question, what law was adopted as of 1791? So for instance, in the case of Heller, the opinion starts off in a textualist more than originalist way. I mean, it's looking for public meaning as of the 1790s, but it's asking, it basically starts off by defining the right to keep and bear arms as the right to have and carry weapons, and only later gets into the debate of why would anyone have ever adopted such a right at the time, and why would it have the particular shape that it might have, and the disputes about the meaning of the English Bill of Rights and so on and so forth, which are addressed later on in the opinion. But I think for an original law approach would be almost the first questions that you would want to ask. What is this doing there? What was the law beforehand? What new legal rule would it have laid down? And what are its contours?
Great. Thanks, Steve. Neal, do you want to respond to anything that Steve has raised here? Steve is offering a different kind of approach that's not necessarily quite as tied to the text specifically, and would use other sources. In terms of what you discovered, Neal, or your background in linguistics, how do you understand this original law originalism in light of these sort of linguistic databases?
Well, I think it's the issue comes down to what are you going to do with the information that is generated by looking at it just on a linguistic level. Although you also doing it just on a linguistic level, you do need to go into some history, because you need to know that helps to explain why something, it makes sense that they would have called use bear arms to mean militarily. It explains why it's reasonable to think that the right to bear arms could have been understood as a right to be in the militia, which Justice Scalia ridiculed. And in fact, there's statements in the equivalent of the congressional record, I guess, of congressional debates where it's basically used that way. So history, certainly, you can't do it in a vacuum from history. But then what you do with that in terms of legal interpretation is a separate question. That's a legal question. So, in statutory interpretation, for instance, where I've also used, and other people have also used corpus linguistics, a lot of people think that's only for textualists, but that's not true, because everybody does consider what, the meaning of the textual meaning of the languages. So purposivists can use, rely on corpus linguistics also, but sometimes it shows that there is not a clear linguistic basis, which then opens the door more for looking at purpose. And that kind of brings up my question to Steve, which is what you said about, discussing the Second Amendment and the First Amendment struck me as similar to really a purposivist approach, which I think that sort of hasn't been how I understood your original law approach, which more had to do with sort of the continuing effects of what was in place then, as I understood it. But is there really, and I'm sure you were really focusing on one aspect of it, but is there a difference really between what you said and sort of a purposivist approach?
So I think the difference is often a purposivist approach is taken as figuring out, what were the purposes behind this instrument, and then how can we advance those purposes today? And that's a very different approach than trying to figure out, okay, what rule did this particular instrument lay down? And we can figure that out in part because of what we know about its purposes. But then once we know that rule, we've got a rule. And then maybe it doesn't achieve those purposes today very much at all. But we still know what law it made at the time. So it might be, for instance, that the idea of a right of ordinary people to keep weapons that would be useful in militia service, for example, and that's one slightly more militia-flavored reading of the Second Amendment than was in Heller, would today be a terrible idea. Maybe it would mean that everybody gets machine guns. Maybe nobody wants that. But that's a very different question than what was the scope of the rule as it was laid down.
Can I follow up on that, Darrell? Yeah, how would that apply? I mean, suppose, let's assume I'm right about that Heller is wrong. And let's assume that Heller actually gets re-examined in the Supreme Court, as long as we're just assuming. And how would, if the right to bear arms means the right to serve in the militia, how does that play out today when the militia then was mandatory universal service, except for a small category of people who were exempt, with trainings that people had to attend, people had to supply their own weapons. It was under the management of the state, and the purpose of it was so we wouldn't have standing armies. Well, we've now got a portion of the population that's armed to the teeth, but doesn't submit to state regulation, as we've seen by the people showing up in Michigan, various state houses around the country, and you've got the rest of the country, which really doesn't want to particularly own guns and have to learn how to use them and be soldiers. And we've also got not only the federal standing army, we've got every one of the 50 states has a standing army in the form of state police. Every city and county has a standing army in the form of a sheriff's department or a police department. So the conditions are unbelievably different. Not to mention the fact that the division in the country, if the purpose of, if one of the purposes of the militia was to be as a counterforce against the central government, how do you deal with the fact that there's enormous differences about what tyranny is? There's the people, there are, so how would I guess what I'm saying, would an original law position deal with that somehow, or would it just say, well, that's, we're stuck with the original law, or we have the original law? I'm not going to prejudice.
So I would say two things. The first is that it's important to remember that the Second Amendment is not just a right to bear arms; it's a right to keep and bear arms. Yeah. And the keep right, obviously, this is disputed, and I should make very clear, I've studied this period some, but I am not an expert on founding or arms regulation. But the keep right seems very much affiliated with contemporary discussions at the time of the founding about whether people would be able to have weapons. And those weapons might be primarily intended for militia service. The picture was, among many people, we want a militia because standing armies are dangerous to liberty. And so we want a well-regulated militia, one that's well-run and well-trained and well-equipped, and that when it gets called up, everybody can show up with their guns. But there were regulations of who could keep arms, and those tended to be very much in the sort of personal possession sense. For instance, the English Bill of Rights, Protestant subjects were allowed to have arms suitable to their condition and as allowed by law. People discussed other laws that restricted the ability of minority groups to keep arms. And so the keep side of the right does seem to be very much associated with a right to personal possession. And the right to bear, even if, and again, this is not my field, but even if it were true that the right to bear arms is primarily one of militia service, it would still be very significant that Congress is not allowed to narrow the scope of the militia. Now, I should note, even today, there's a section of 10 USC that provides the unorganized militia of the United States, includes all non-disabled male citizens between 17 and 45, among other groups. So there's still a sense in which the three of us here are all members of the unorganized militia of the United States and presumably of our respective states.
I've aged out.
But I think, oh, sure, go ahead.
No, go ahead and finish your thought, and I want to.
And just to say that, Elbridge Gerry at the founding worried about the idea of Congress using conscientious objector clauses to narrow the scope of the militia until it turned into a select militia, like the modern National Guard, that only a very tiny number of people are actually enrolled in. So it might well be that the original scope of the right, and again, this is not a firm conclusion on my part, was that in general, the main body of the people can't be prevented from having weapons and then being able to use them in militia service.
So I've got a question for both of you. It's a sort of different version, I guess, of a similar root, which is, so one of the appeals and the enduring appeals of originalism, I think even for non-originalists, is the promise that it takes the politics out of judge making, out of judicial decision making. That is, or at least it reduces it. Might not be able to destroy it, but it reduces the scope of discretion for judges. Now, there's a couple of things that I heard in your comments that I'd like you to respond to in turn. Neal, you had said something like, well, we might be able to sort of falsify what keep and bear arms or bear arms means in 1791 using these new techniques of looking at the corpus, trying to figure out what a common speaker of English would understand, how a common speaker of English would have used those terms. But that doesn't necessarily answer the legal question. And this is the phenomena that Larry Sullum, among others, has said between the interpretation and construction division. Now, so I got a question for Neal, which is like, what are we about in terms of a corpus linguistics if you don't concede that there is some relevance or necessary relationship between the falsifiable legal terms and the legal content? And for Steve, I got a different question, but the same root, which is, a theory of original public law sounds great, but where is the objective falsifiableness of the theory? That is, if you promote a certain view about what original law was, whether it has to do with the Second Amendment or the First or the Third or whatever, how does one go about falsifying the theory that you have about what original public law was? It seems like you sort of put the rabbit back in the hat with original public law of the kind of discretion that originalism was supposed to rid us of. So, you can take, Neal, why don't you take the question first and then Steve?
Sure. I mean, the short answer is the corpus linguistics really doesn't have any role to play in the kind of issues that you raised. I mean, corpus linguistics is not a theory of legal interpretation. It's a method, an approach to dealing with figuring out textual issues, how the language is likely to have been understood. Once you've done that, I don't think the corpus linguistics really has that much other relevance. There's other, aspects of linguistics or philosophy of language that can come in when you're talking about, what the word meant versus how it is applied, and there's various, other complications that would feed more directly into the legal issues. But even then, it's just really talking about how you understand the language and then what a judge does with that in terms of turning that into a legal rule is just a matter for the law. Linguistics I don't think it has anything to say about that.
Steve?
So first of all, I just want to make very clear, I don't, object to corpus linguistics in general. I think it can be a useful tool in the same way that dictionaries can be a useful tool, indeed, maybe even a better tool than most dictionaries. It's just that it might not be the be all and end all of what the legal inquiry is. On the question of constraint and, how do we take the politics out of judging? How do we make it more mechanical? It is certainly true that modern versions of originalism, even original public meaning among them, enable a lot more uncertainty than we're going to see what precisely was in Madison's head, and if he didn't think of it, isn't there. Now one argument might be, look, certainty is an advantage sometimes of originalism, but it's not the end goal. If all you really wanted was to have a very determinate constitution, then you'd get a lot more certainty if you just drop the 5th and 14th Amendments. Like, those are really hard. We can just drop those and then we'll just get much more mechanical decision making. But nobody thinks that that would be following the law. Likewise, you can take the politics out of judging if judges just flip coins every time. There's no politics whatsoever. It's just the coin flip, but it still wouldn't be following the law. So the way in which original law originalism is constraining is to say, look, you've got to have a satisfactory legal argument. You've got to be able to show that this was the rule as of this past time. Now, what kind of sources can you look to? What kind of arguments can you make? There are, a variety of sources. If we ourselves were trying to figure out, the property law of Virginia in 1800, and sometimes cases have to do that to figure out, who owns Blackacre. There are lots of, treatises and statutes and cases and sources that you would look to try and identify what that was. It doesn't mean there's a magic formula or recipe for putting all those sources together and getting a legal rule out any more than there is today for trying to figure out what the property law of Virginia is on some difficult question. But the claim of original law originalism is just whatever is the right answer as of 1791 is still the right answer today, unless something legally relevant has happened that would change the rule that was laid down.
Neal, do you have any response to that?
No, well, the only thing would be probably the least important of what Steve said from his point of view, which is that dictionaries are really problematic. And one of the reasons for that is demonstrated by what we found out from the Corpus study, which is dictionaries are not even a snapshot. They're little marks, recording, these are ways the word has been used. And it says nothing about how common it was and which usage was predominant. It's just a card catalog of usages. So you get a very misleading impression from the dictionary, because even the Oxford English Dictionary, which actually is the only one I think that should be given any credence on historical stuff, because it's much better researched. But even if you look there, the carry arms, carry weapons interpretation of bear arms finds support just as does the, be a soldier and fight in a war. So there's no, it's a coin toss between those two. As far as the dictionary goes, when you look at the corpus data, it's a totally different picture. So, I'm very, I would say never look at the dictionary, but you have to really be careful and know what you're doing also.
One thing I would say quickly in dictionaries' defense, although I neither bear nor carry any brief for dictionaries, is that they're often phrased in categorical terms that can sometimes be useful. So for instance, a standard example is an airplane a vehicle? And this gets fought over both sides. There's a Supreme Court case that says, no, it isn't for the purposes of the National Motor Vehicle Theft Act. On the other hand, if you taxi an airplane through the middle of a park, you have probably violated the no vehicles in the park ordinance. And so the fact that you would never see in a corpus people using airplane and vehicle in the same context, just because that's not how we talk about it generally. When people are presented with a list of conveyances and asked, is an airplane a vehicle? Often they say yes. And so part of the great use of corpus linguistics is it captures the body of practices that a good dictionary is also trying to capture. The downside is it may give you less information about the edge cases or the categorical nature. Sort of what's the means of finding out, means of picking out whether this is a vehicle or not. What are the things that tie all these uses together? That requires additional work. And hopefully a good dictionary has done that work, but often not.
Right, but I mean, dictionaries really don't do anything other than try to summarize usage. So to regard those as a guide to categorization is wrong, and any lexicographer would agree with that. Now, categorization, the kind of things you're talking about, is actually much more complicated than anyone realizes. There's an enormous body of psychological and linguistic and philosophical literature. And there is some uses in the corpus, because I've looked, where people do seem to regard airplanes as vehicles. But that's not how it's ordinarily used. But you get into a question of, is the question whether an airplane is regarded as a vehicle? Is a tomato regarded as a vegetable, or is it a vegetable? There's that tension between sort of a conventionalist approach, or how is something regarded, the category of a vegetable is actually socially constructed, because it's just an oddball collection of plant things that we happen to cook with, or is it somehow real? This is the shape of reality. This is this is or is not a vehicle. It is or is not a vegetable. And courts go back and forth between those two things. So I don't know that it's tractable at all, regardless of what resource you use. But that's getting way afield.
So I want to just put one more thing on the table in our last 5 minutes or so here, which is, as you know, a couple of scholars, Rappaport and McGinnis, have a kind of a different take on this, a different theory of originalism, which is really about original methods, and at least my reading of their interpretive move is it's very much focused on lawyers and understanding the Constitution in a legal framework, which seems to marry both of your insights about originalism. So to Neal, the question would be, well, why wouldn't we reduce the denominator of of relevant materials just to the usages by lawyers? And to Stephen, the question would be, well, why can't, since we are trafficking in a common law system, why wouldn't that presuppose that there is no original law, because the original law is going to evolve over time in a common law fashion, which would have been well known to the founding generation. So in the last few minutes, those questions.
Yeah, I think I'm going to again say I really don't have a whole lot to say about what the choice of interpretive theory should be. I mean, I can talk about what the implications of various theories are, and what the implications of corpus linguistics might be for that. But I don't, that's not anything I can have anything to contribute on, really, that other people can't do better. And as far as the corpus, the corpus issue, I think it might be hard to find, specifically identify legal lawyers using legal terminology from something else. But I suspect also that for most things, it's not going to be that difficult to identify legal terminology, because it's going to be discussed in law dictionaries. That would be one actual example where, dictionary would be useful, because it shows that this has a particular, meaning in this specialized domain. But beyond that, I don't have anything to really add.
And so I would agree with part of that. I think that and indeed you can build a legal corpus. I mean, you can look specifically to legal sources to try and identify how lawyers are using this word, and are they using it differently. I think what's important in trying to understand what the status of an unwritten or common law rule was at a particular time is that much like language, even though language rules evolve over time, but that still allows us to say, well, at this particular time, this is the best way to understand that phrase, or this was the most common or best accepted use of that phrase, even though today it might have something very different. Someone who described something as awful in the 16th century might have meant more like awesome today. Given that fact, if the Constitution protected certain then existing common law rules against statutory abrogation, that doesn't necessarily mean that sort of whatever those rules later evolve into is equally protected, or whatever people now regard as a right to keep and bear arms. It might be the one that we are looking at right now is now protected against congressional abrogation. So I think that the legal question would really be, are they protecting, tort law, period, some giant category that we know evolves, Or are they saying this particular rule of common law, this, the fellow servant rule or something, is being protected? And I think those have very different legal implications for what happens later on.
All right, in the last few minutes, really quickly, if we were relitigating District of Columbia versus Heller, and you had the opportunity to put in, a brief, knowing what you know now, in a couple paragraphs, what would it say, Neal?
Well, I actually did file a brief that dealt with that, which said that here's this corpus linguistic analysis that undermines Heller, but don't decide the Second Amendment issue because this should be debated and let it percolate, let it be litigated, and not deal with it until it kind of gets a thorough airing, which I hope that hasn't really happened yet. I would hope it would. And I hope that the gun rights people will address the issue, which so far they've studiously avoided.
And I would, before filing any amicus brief, want a great deal more expertise in the history than I currently possess. But I think I would say, look, you don't have to have an individualist reading of Baer as Carey for there to be an individual right in the amendment. The right to keep weapons is generally thought of as something that individuals might possess. And the right to the militia-focused reading of bear arms, in fact, might produce a broader Second Amendment right to keep weapons than the one that the court actually recognized. I think that the fight between sort of the individual-focused and the militia-focused readings of the amendment may not be a coherent fight. It might be possible to read them both together as a right to keep weapons that one could then use in militia service.
Terrific. Thank you guys so much again for your flexibility, for rescheduling this on Zoom. This was a really, really interesting and enlightening discussion. Please, for those of you that are watching this online, you can send any questions or comments that you have to firearms@law.duke.edu. And you can check us out online at law.duke.edu/firearms. Follow us on Twitter at Duke Firearms Law, or subscribe to our blog, Second Thoughts, which you can find on the Duke Center for Firearms Law webpage. Neal, Steve, thank you again so much. Be well, everybody.
Thank you.
Thank you.